Welcome to the Business Scholarship Podcast, a place for interdisciplinary conversations in the broad world of business research. My name is Andrew Jennings, and it's my pleasure to be your host. If you like what you hear today, please subscribe to the podcast on Apple, Spotify, or wherever you get your podcast. Plus, leave a rating and let other people know about the show too. And if you have ideas for the show, please let me know. My email address is andrew@andrewkjennings.com, and I look forward to hearing from you. All right, time for the episode. Our guest today is Anne Choike, Associate Clinical Professor of Law at Michigan State University. We'll be discussing her new paper, Local Corporate Law, which I'll add a link to in the show notes for the episode. Anne, welcome to the Business Scholarship Podcast.
Thanks so much, Andrew. I'm happy to be here.
And when I initially saw this paper, I think on the SSRN Digest, I was really intrigued by the title. I think it's a provocative title in a sense because generally we don't think of corporate law as being local in nature. We think of it as being state-based in the United States and perhaps having some federal elements. But before we maybe get into this concept of local corporate law, I wonder if you could level set with a concept that's probably somewhat familiar to a lot of listeners, but perhaps not as familiar to others, which is just what is corporate law? What are the sources of that law? And you introduce a concept of corporate federalism. Could you talk to us a little bit about corporate federalism and perhaps the state and federal influences or sources of corporate law?
So I think that starting with what the definition of corporate law is, what its sources are, important and integral to the article, because my article and its argument really depend upon this evolving landscape of corporate law. I broadly refer to corporate law to mean all legally binding rules, whether originating from governmental institutions, as we traditionally think of state and sometimes federal law, as well as private law contracts among market participants that do one of two things. First, concern the establishment of an organization as an entity with separate legal personality, or address the allocation of power among certain constituents within the firm, perhaps between owners and managers or among owners, as well as between the firm and stakeholders. And of course, corporate law is particularly interested in the agency relationships and problems unique to organizations, not just any agency relationships that agency law governs and considers generally. And corporate law in particular is concerned with addressing the relationships between the entity and any owners that it may have, as well as the relationship between those owners and the entity's managers and other representatives as agents. I think historically, corporate law scope was broader than these two areas. Many states restricted corporations' purpose and size and activities into the mid-19th century. And I think that it's possible that local corporate law, with some of its concerns regarding these topics, may represent the pendulum swinging back. Maybe not all the way back to that extreme origin, but certainly some of the way there. As far as corporate law's sources, I think that corporate law's sources have expanded, or we can think of them as maybe broader than just the state enabling statutes, the federal laws like Sarbanes-Oxley and Dodd-Frank that have been a source of federal corporate governance. And I think most significantly, what I mean when I say that corporate law's sources are expanding, of course, to any corporate lawyer thinking about the private law documents that corporations and firms use to establish their existence and manage these relationships are not a new source, but thinking about, for example, contracts as a source of corporate governance. LLCs are a contractualized entity, but what about other contracts that contain governance provisions? Local corporate law depends on contracts between governments and entities, and I'm arguing that these contracts do contain provisions that impact corporate governance, and therefore these contracts between governments and entities are no less corporate law accordingly. As to your question about corporate federalism, so corporate federalism is the balance that's struck between state and federal allocation of corporate regulation. In the conventional conception of corporate federalism, states govern organizations' establishment and internal affairs, such as board composition, and the federal government mostly regulates their external affairs, such as the environmental impact of corporate activities. So, of course, as with those federal laws that I just mentioned, Dodd-Frank, Sarbanes-Oxley, others, that has been increasing, and whether or not that's a good thing, there are differing opinions about. In the field of corporate law, it's Delaware, other states, and sometimes the federal government who have created corporate law under this conventional conception of corporate federalism with no meaningful role for local governments, such as cities, until now, as I argue in my paper.
So in the paper, you make the case that localities like cities and counties have part to play in corporate law and corporate governance. Perhaps introduce that concept, what you mean by local corporate law. How are localities venturing into this regulatory picture?
Yeah. So my paper describes for the first time that across the country, cities and other localities of really every size have recently undertaken initiatives that resemble corporate law. These novel local laws range from requiring board diversity and promoting stakeholder governance or engagement in corporations and other firms to supporting the establishment of worker cooperatives or other specified types of entities, constraining C-suite compensation, and even in some cases, limiting core corporate features such as limited liability. The rise of cities as creators of corporate law should puzzle anyone who's taken business associations. And I think this is because these developments defy the framework of corporate federalism that I had just described. My article sees, names, and explores these local initiatives for the first time as local corporate law, and also illuminates and analyzes how they have the potential to revolutionize corporate law. The part of my article that I'm currently revising is also showing how local government law is impacted by the rise of these local initiatives as well.
Could you give us some examples of just what localities are doing out there in terms of adopting local laws? Is this something that is isolated to particular types of jurisdictions or geographies, or maybe partisan or ideological backgrounds in the communities or the governing councils of these localities? Or is this something that's happening across the board or more broadly?
Yeah, the local laws encompass a variety of initiatives in which local governments have used their legal authority to encourage or even demand, I would say, sustainability and generally corporate social responsibility. But what's interesting is that these initiatives have really been coming from localities that comprise the full range of the political spectrum, as well as the full range of different sizes of cities. I haven't actually looked in any sort of methodical sense and counted the number of local corporate laws that I've gathered to really assess the balance of how many of these are coming from red cities, blue cities, cities in red states or blue states, swing states. But I can say that just from broadly looking at them, there are some from cities that are in red cities in swing states. There's certainly a lot of them are in blue cities that are in red states. In terms of the types of initiatives that they comprise, board diversity mandates for organizations doing business with or receiving funding from cities. These local initiatives address the establishment of businesses organized as worker cooperatives or seek to encourage entities to adopt stakeholder governance or form as stakeholder governed entities. They seek to limit executive compensation in order to address income inequality between firms' executives and workers. They seek to promote stakeholder engagement by firms. And some of the most extreme examples, which in my latest draft, I'm really limiting the airspace that I'm giving to this final category of potential corporate law, what I've called local disabling statutes, because they're on such tenable legal standing that they really seem more like political theater and then valid and viable law. These are local ordinances that originally, in their earliest forms, purported to strip corporations of their legal personality. In their evolved form, they disable some of the core features, even if they maintain the legal personality. They did not have the authority to strip in the first place, but they seek to impose unlimited liability for environmental pollution. But they're just such a complicated case. And I worry that they might be a distraction because they are absolutely fascinating. And then it was so hard to take them out of my article because they were among the first local initiatives that I thought might fall within this category of local corporate law. There's a principle in writing that you need to kill your darlings in order to make your writing better. And they were definitely my darling. But I do hope to revisit them in a future paper. But I think that's a full range of the local corporate laws that I've looked at.
I'd like to come to some of the legal standing issues that you allude to in a few moments. But first, as I was reading this paper, I had several questions around distinctions for these local corporate laws. And I think some of the distinctions might help us understand the concept more deeply and understand some of the borders of this concept of local corporate law. So I want to maybe ask you three questions about distinctions. I'll just perhaps take them one by one. The first is, Could you talk a little bit about the distinction between corporate law from laws that regulate what corporations don't do, can't do, must do? What's the distinction there between corporate law and that positive external regulation?
I guess I'll preface my answer by saying I think that this is a really challenging, persistent issue in corporate law. The distinction between internal and external is one that I think is currently buckling under the pressure of the internal affairs doctrine and its expansiveness and rigidity. So as I have approached this very challenging question and tried to make sense of it, the answer that I've arrived upon and reserve right to further revise as I continue to develop the idea in my article and future work. I think that what makes something corporate law is not about the ambition or the desired outcome of the law, but rather about the means of achieving that outcome. And if the way that a government tries to achieve its ambition or desired outcome is through firm structure or altering the fundamental relationships of power in organizations through organizational initiatives that look like or that function or have the mechanisms of organizational law, then I think that you're trying to achieve your means through corporate law. And to me, that's what makes something corporate law, regardless of whether it's at the traditional state level, federal level, or as I argue, a local level. So one example, rather than saying that all firms must pay workers a minimum wage and provide safe working conditions as employment law and occupational health and safety laws do. And those are laws that regulate firms' activities as opposed to corporate law, which affects their structure and the relationships among the constituents. I think corporate law approaches these questions. So the same ambitions, desired outcomes, you might say, by fundamentally reimagining the role of workers within firms, worker representatives on board, worker ownership. If these workers have this power, if they have this role within firm structure, maybe the issues that are posed or raised that these laws addressing minimum wage, safe working conditions will be resolved by the firm constituents themselves rather than meeting the specified standards set by lawmakers external to the firm. I think that laws that regulate what corporations do apply without regard to firm structure or allocation of power among constituents, unlike corporate law, which has these issues of firm structure and allocation of power among constituents as its principal concern. So another example might be the board composition and specifically board diversity as corporate law and anti-discrimination laws as laws affecting corporations. On the other hand, board composition mandates address the extent of the power that shareholders have to choose board members. And maybe governments, local governments are trying to achieve demographic equity with their board diversity mandates that I identify in my article and not necessarily improve firm governance metrics or other objectives that we traditionally associate with corporate law, although I will say that I don't think that those are necessarily mutually exclusive, but they're doing that through board diversity mandates. It doesn't mean that these are not corporate law just because the local governments are using this novel mechanism.
In the paper, you talk about a few different sources of local corporate law. On one hand, there might be an ordinance or statute adopted by a city council or a county council. On the other hand, you might have elected officials within a locality, say a city comptroller, announce a policy as to how they're going to exercise the discretion that they have as office holders. Is there a meaningful distinction between those two sources of law or any sources of law that might occur in the middle there, or any line drawing that we should do in terms of ordinances on perhaps one extreme versus discretionary policies of officials on the other side?
I think that's a really meaningful distinction. And it's actually one of the most exciting parts of the project to me right now, where the intersection of local government law and corporate law really comes alive. And I'm currently revising my paper now to really surface it better and do it justice. You highlighted some of the distinctions that are relevant. For example, whether these local initiatives are enacted through the local executive branch or the local legislature. In addition, local corporate laws can be differentiated according to the scope of local government authority power through which they're enacted. And there's other distinctions I'm exploring in addition to these two, but these are the two that I've looked at so far. So with respect to the distinction between local initiatives of the local legislature, like ordinances and resolutions, versus initiatives of the local executive, budget allocation, policies of an agency like the City of New York Comptroller, So I think that this distinction between the local legislative and local executive initiatives can be illustrated really well by the worker co-op program examples that I have in my article right now. An example of a local initiative through the legislative power, New York has a local ordinance that mandates disclosure by the city on the status of worker co-op businesses that have received procurement contracts and the status and progress of its worker co-op programs. That's actually in the local laws that the agency has to report on this. Meanwhile, it also has some initiatives that it's pursued through its local executive power, as does Berkeley. Berkeley has changed its licensing paperwork, which is through its local agency, established a local revolving loan fund in order to provide worker cooperatives with access to the capital they need to convert into worker cooperatives. Work cooperatives have challenges getting loans because if they need to offer a personal guarantee, it's really not clear which owner should be providing that personal guarantee. And so Berkeley established a revolving loan fund that made it easier for worker co-ops to get loans for the businesses by setting forth a framework about who would be required to provide those personal guarantees, how many owners, et cetera. They've also promulgated educational materials. These are all examples of, I believe, the actions of the executive. And I say that cautiously because I am learning all of this local government law myself at this time. And it's exciting to me. This is why this part of the paper it remains in progress. But the reason that this is a significant distinction to explore between the legislative and the executive is because it may have implications for how vulnerable these initiatives are to preemption. The executive power is more expansive. The local legislature may be more subject to a phenomenon in local government law that's been referred to as the new preemption. The new preemption is when blue cities in red states are trying to capitalize upon the power that they have economically and otherwise as cities in states that have declining budgets and maybe some other political issues. And these states are using their power as states to preempt cities' initiatives as they try to be more forward-looking. It has to do with the scope of authority through which the local government acts. I think a brief primer on local government law here is necessary. Just to understand that the nature of local government is multifaceted, and they act in different capacities at different times, sometimes as an agent of their chartering state. So like how states have agencies to execute different administrative functions, you can think about localities as agents as well, only they're territorially focused instead of focused on particular administrative functions. And at other times, local governments act in a quasi-private proprietary role, pursuant to the power that any market participant has. And this difference in capacity through which local governments act is actually really important because each of the capacities has different scopes of authority that the local government can utilize. In the quasi-private proprietary role, when a government acts in its private and proprietary powers, its scope of authority is broader. For example, when New York is acting on behalf of its pension funds as an investor, as a shareholder, it has broader power than, for example, when a local government is acting as an agent of the state. For example, when Minnesota is acting to fund and support civic neighborhood organizations and decides to ratchet up board composition requirements for the nonprofits that are receiving that funding. Both of these situations involve board diversity, but they're different in that New York City Comptroller is acting in its proprietary function of local government. Minneapolis is acting as an agent of the state. And even cities that have the most expansive delegations from the state to act, and these delegations vary from city to city, vary with according to states. I won't get into all of the local government nitty-gritty, but I think it suffices to say that even when cities have the most expansive power delegated to them available, there is still something called the private law exception to these expansive grants, which is that enactments of private or civil law governing civil relationships where affairs exclusively those of the state, such as the law of contracts, are outside of that scope of authority. And so this is all to say that even though these local initiatives might look the same from a corporate law perspective, they're both addressing board diversity. They're very different from a local government perspective.
At the top of the interview, I described the title of the paper and perhaps the concept embodied by the paper as a provocative for folks who are accustomed to the corporate law federalism that we talked about at the top. So I'd like to perhaps consider some questions or objections that might feed into perhaps the provocation that your paper offers. The first is, in a national or arguably global market for corporate law, to what extent are local corporate laws either socially or economically necessary? Are there any gaps that they feel that other sources of law are perhaps not addressing, such that we need localities to enter into this space?
I agree that it's a provocative title, and I certainly do not want to overstate the contributions of local corporate law and opine regarding their nature as socially or economically optimal. That being said, I do think that local corporate law can make important contributions to the economic efficiency of corporate law at the very least, and also promote some socially desirable policy considerations. So with respect to efficiency, to date, the broader debate about the market for corporate law has focused on the dynamics between the state and federal government, among states, and within states among powerful groups acting upon state government. Yet these forces are not the only powerful influences upon the production of corporate law. Local jurisdictions, their constituents, and local level historical, political, economic, and other considerations also matter. To that end, one of the contributions that I think local corporate law can make to the efficiency of corporate law more generally is to take into account these previously overlooked dynamics. Corporations are not situated uniformly across jurisdictions. Sub-state level localities can have very different concerns from one another to the extent that the siting of corporate activities varies across them. And these divergent concerns might not be reflected in state or federal corporate laws. That's because not only is corporate law at these levels dominated by the corporate bar, representing the interests of large corporate clients, but also local constituencies may be less successful forming political coalitions to influence corporate establishment, governance structure, and rights at state and federal levels. This is because cities compete with one another for resources in a hierarchical system of cities, according to urban scholars and theorists. And the local lawmaking process might manifest a different political economy than the production of corporate law at state and federal levels, and result in corporate stakeholders' concerns reflected in local laws and ordinances regulating corporations. Better taking into account the considerations specific to localities can also be a socially desirable outcome of local corporate law. For example, local corporate law might enable localities to better serve their constituents in ways that they have been unable to due to constraints on local government law authority. And local corporate law could also enhance the legitimacy of corporate law by addressing the concerns of stakeholders whose interests have not really been considered to date.
Shifting from an efficiency consideration, I want to turn to a normative/doctrinal consideration. To what extent does the practice, the adoption, the use of local corporate law subvert or potentially even enhance state corporate law? And what legal barriers or challenges do you see potentially challenging local corporate law or that have already challenged local corporate law?
Sure. With respect to subverting or enhancing existing state corporate law, I think that it's both and. I think in principle, local corporate law can both complement and subvert state corporate law, depending on how it's structured. Even if you are a proponent of the competition for charters among states, there's no reason that localities cannot help produce efficient and desirable corporate law as well. I think that, of course, there's concern that there could be conflict among localities, or rather between localities and state law. I think that this problem already exists under state competition for corporate law. California adopted board diversity mandates that conflict with Delaware's lack of such a requirement, but this conflict is not irreconcilable in theory. Firms can both comply with California and Delaware. And practically, I think that cities want to fit into the existing framework. These aren't mandates that are fundamentally at odds with state corporate law. For example, a city saying that you must have 2 or less diverse directors and a state saying you must have 3 or more, which just would not be possible to comply with. So I think that the issue of conflict and the ability to legally comply with both state and local corporate law is a tough question in the abstract more than it is in reality. I think in theory, it's also possible that local corporate laws could dilute Delaware's influence. because wherever you operate, you will be subject to local corporate law, regardless of where you're organized, not only Delaware law. But corporations aren't just choosing Delaware for its substantive laws or for lack thereof, its extensive default law structure. They choose Delaware for the greater certainty that comes with a tested legal framework that jurists expert in business law have developed more than any other state. And that's not going to go away just because localities undertake initiatives on selected or even more comprehensive aspects of corporate law. With respect to the issue of legal barriers and challenges to local corporate law, as I alluded to it just a moment earlier, I think that some of these issues are raised by existing issues in corporate law from the state level. For example, I think that constituency statutes face similar constitutional challenges from the Dormant Commerce Clause and the Contracts Clause that these constituency statute-like community engagement ordinances raise. I guess the first challenge that comes to mind, though, when I think of local corporate law and the challenges it confronts on the corporate law side. But of course, I think of the internal affairs doctrine that the chartering state is the one that controls the entity's internal affairs. The ordinances that require community engagement are the ones that sort of raise this most significantly. Of course, you could view them as not mandatory and not triggering the internal affairs doctrine because firms do not need to accept tax incentives and therefore they're not mandatory and firms don't need to be subject to the community engagement requirements that these tax incentives require that firms take into account if they want the tax incentives. But on that logic, California board diversity wouldn't trigger the internal affairs doctrine either because firms don't need to have their offices in California. So I don't think that's really the way to think about it. Assuming that these community engagement requirements on a local level do address internal affairs, I think that that's the most significant legal challenge, the internal affairs doctrine. In addition to, of course, needing to explore the Dormant Commerce Clause challenges and other constitutional challenges. Other local corporate laws don't really raise the internal affairs issues in the same way, though. For example, Minneapolis's board diversity mandates apply to nonprofits. The New York comptroller, that's not mandatory law. That's just shareholder activism. That's how I'm thinking about this now, but it is a really challenging question and one that I have not completed my analysis of.
I wonder if there are any key takeaways you'd like to offer listeners of this interview or readers of the paper. And you've alluded to some open questions that perhaps you'll tackle in the future. So if there are any previews of future projects you'd like to offer, would love to hear about those.
Key takeaways. I think one of the main takeaways that I want listeners to gain from this interview is just that local corporate law can illuminate new perspectives that address traditional corporate law issues. And I think one issue that illuminates this benefit of local corporate law is board diversity. So states and self-regulatory organizations have primarily only addressed for-profit companies with the board diversity mandates or regulations, whereas local corporate laws have, with some exception, primarily addressed only nonprofits. And I think this is a really interesting difference that states and self-regulatory organizations have addressed for-profits, local corporate law have only addressed nonprofits. I think it makes us think about what is the role of board diversity? What is its place with respect and purpose in advancing the profit imperative of a firm? I think that's especially important as you think about nonprofits, which certainly can be well run, but they can't be operated for a profit. And does that tell us something about the purpose of board diversity as important for ends that are not only firm value enhancing? In terms of future projects, I'm continuing to explore the intersection of local concerns and corporate law, a project that I'm really excited about that I've already gotten started on. Actually grew out of this project. I'm working on a project about regional stock exchanges. And there's a really interesting example that I've found where actually a local government, a county, used some of its park money to provide a loan to a regional stock exchange. And we think of regional stock exchanges as not really existing anymore. The last regional stock exchange arguably closed in the early 2000s when it moved from its Midwest location to New Jersey and renamed itself. It was the Cincinnati Stock Exchange, and I believe it became the National Stock Exchange. And that was arguably the last of the regional stock exchanges. But in 2017, the county of Newcastle in Delaware supported the establishment through this loan of the Delaware Board of Trade. I'm debating whether or not this is something to include or mention in the local corporate law article. I think probably not. I do think that it raises some interesting issues about the firm structure of these important trading venues. And we know that their structure does impact their operations. But at any rate, I'm continuing to explore this really fruitful intersection of local government, local and urban theory, and corporate law with regional securities exchanges. And I would love to return to the podcast at a later time to talk about that project when it's ready.
All right, that sounds good. Look forward to having you back when that next project has come along. Our guest today has been Anne Choike, Associate Clinical Professor of Law at Michigan State University. We've discussed her new paper, Local Corporate Law, which I'll add a link to in the show notes for the episode. Anne, thank you for joining the Business Scholarship Podcast.
Thank you so much, Andrew.
Thank you for listening to another episode of the Business Scholarship Podcast. If you like what you heard today, be sure to subscribe to the podcast on Apple, Spotify, or wherever you get your podcasts, rate the show, and let other people know about it too. If you have ideas for future episodes, let me know. My email address is andrew@andrewkjennings.com, and I look forward to hearing from you. Until the next time, I'm your host, Andrew Jennings.